Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. She is the Vice President of Economic Strategy and the Chief Economist at Qualcomm. I'm very, very happy to have here on my SEP Couch today, Kirti Gupta. Welcome, Kirti.
Thank you for having me, Tim.
It is really good having you. And like always, I want to know more about you as a person. And I know you very well since several years now. But tell us a bit, how did you get started? How did you end up with working with, all these topics we care a lot about, SEPs, FRAND, negotiations, all that? How did you get there? What does your career look like?
Gosh, Tim, I think we've known each other, over a decade, over 10 years. And at that time, we were both finishing our economics Ph.Ds in intellectual property and innovation. And as you know, my experience with standards goes well before that. I started working at Qualcomm in early 2000s after graduate work in electrical engineering as a wireless engineer for designing what we call third generation and fourth generation wireless systems. And part of this work was, early R&D and prototyping, and part of it was going to these international standards bodies for sharing those inventions and with a broad community of engineers to try to select the most, appropriate technology for these technology standards that we were working on. And so my early foray into standards was as an engineer. I have several patents that are, I think, potentially essential to the standards or SEPs here on my wall in my office. And then I think I can say this to a fellow economist, I turned to the dark side of the dismal science of economics, and it's been quite a journey to hear about these, economic policy, legal aspects over the last 10 years.
That is great. And Kirti, and you're right, we know each other more than 10 years. I thought it was always exciting because we talked about all this, who goes to standards meetings, what does a claim chart look like? And you were probably the only economist people I knew who actually has own patents, who knows what a claim chart look like and who can understand a claim chart. Do you think your technical background, knowing all this, knowing how to specify a standard, and going to the 3GPP meetings yourself as an engineer, not as an economist, did that help you also with your economic analysis and your perspective on technology that we all discuss and talk about?
I think that technical knowledge is critical, Tim. So, I started off with my career as I'll start again. I started off with my career as an electrical engineer, and I moved to what we used to call the strategic IP department at Qualcomm. And there we would do a whole bunch of claim charting. And these claim charts are always written with a combination of engineers and lawyers. So it really, without that technical knowledge, I think it's really difficult to be embroiled in these, claim charting process or these discussions. So I would like to share with you a few things that I see from a policy perspective that I think are lacking in our discussion because we don't have the technical element present.
Yeah, that'd be great, actually, if you could elaborate. And that also puts me to my next question. I mean, there is a lot of policy debate these days, right? We have public consultations from the US, Canada, UK, also Europe recently, and they all have different things in mind. And one idea that also, especially in Europe, has been discussed a lot is about transparency and things like we should set up a database of claim charts to have more transparency. So that doesn't exist right now. We know that patents declared are potentially essential, but no one, provides evidence if they are or if they're not, because the databases were not designed for this. But do you think such a database of publicly available information on claim charts is something that makes sense to you? And who should be claim charting, and how would that work?
So let's take a step back. I think before we jump to the question of transparency and claim charts, here is my overall issue with the policy discussions we have on SEP and FRAND. My major concern is that we launch headlong into discussions on policy and technical solutions without the big picture of understanding the ecosystem. And from an engineering perspective, my first point is that standards are like the blueprint of a building. It's the foundation upon which the mobile ecosystem rests. If we don't have the protocols to speak with each other and to communicate over wireless channels, we have nothing. The products and the applications and all the things that we use aren't simply going to work, right? So we first ought to recognize that these are the blueprint and they create this enormous value. Let me take the GSMA, for example, 2019, $4.8 trillion in revenues, right? The second point that I feel we miss is that these are incredibly complex technologies. And this relates to your question of claim charts and transparency and all that. They aren't just about interoperability, about making sure that everybody's using the same language or driving across the same lane. It's really about creating cutting edge solutions to technical problems that don't have a solution yet. Security, very complex coding algorithms that are mathematical algorithms that are generated every generation or so, right? These are the things that are embodied in a standard, just to name a few examples. And the third thing that's missed is the scope of these technologies. The last version of 4G standards, LTE, which we all use in our phones, right? Last I checked was over 1,500 technical specifications or thick documents. So they can fill this room that I'm sitting in. So, and it's not like, this is work of thousands of engineers that work on various different aspects of the technology. I used to work on system architecture. I can assure you that people who were working on different working groups like security or location services or coding algorithms, we won't even be speaking a common engineering language. This is how rich and complex this tech ecosystem and standards is. And that's the last thing I would say, fourth reason is we can't overlook is when economists like you and me come up with beautiful models of, ex ante and ex post world, and a standard was just endowed upon earth from nowhere. That's just not reality. These are very complex technologies that are iteratively generated over a long period of time, over a number of releases, over a number of years. So these are some things that I would like us to keep in the back of our mind to discuss the questions of transparency and claim charts. So let's go to that.
Right. No, it's great that you elaborate on this, and that's always what I liked about it. What's going on in the technical world. So yeah, now since we have an understanding, let's talk about some policy, proposals. And I would love to hear from you. What do you think about those?
Okay, so I think, let's start with your question that you raised, Tim, of the claim charts, and then we go to transparency. So, in all of these discussions that are happening right now, the JPO, the European Commission, the DOJ in the US, I'm not sure I've seen regulators asking for publicly available claim chart data, because there is a recognition that at least in the licensing and patenting community, that, as you said, the drawing up of claim charts for patents is an incredibly complex and therefore costly technical exercise. You have to dissect what the claim scope is, what products that they're reading on, and that's an incredibly detailed technical job. So as a usual practice, claim charts are shared during confidential licensing negotiations with an NDA. And I'm not a licensing manager. I'm not a business developer who goes and negotiates licenses, but I've written documents for these kinds of things. And in our experience, I have often known that NDAs are both desired by the rights holders and the implementers as a means of protecting confidential information that is covered in these claim charts. Because licensees want to, want to facilitate the exchange of confidential information, such as, the claim chart, infringement analysis, et cetera, which aid and assist in negotiating the FRAND rate. But licensees are also hesitant about disclosing, some information about their business models, future product plans, financial details like sales and volumes that go into the dissection of the claims in the claim chart. So it's really important that regulators, like by the way, the JPO did in their 2018 guidelines, incentivize and encourage the use of these claim charts in negotiations between parties. If we go towards a path of, public disclosures, we will find that it's very hard for any central party to carry out this analysis in a way that serves the needs of either the licensees or the licensors.
And why do you think that is so? Is it, I can fully understand that, the best party to conduct claim charting is the inventor or the company that, owns those patents, because you are the inventors of that technology. But just to elaborate on it, how many experts would it need, you think, to actually conduct a claim charting that is meaningful? Would that have to be people that go to 3GPP meetings? Would that have to be patent attorneys or a team of those? Could you elaborate a bit on that?
Of those. Yeah, it would have to be a combination of those, and also experts who understand what are the products in the marketplace and what those products are implementing that the claims may read on. So you can immediately understand what a complex and detailed exercise this is. And this claim charts in particular is far more demanding in terms of time, complexity, skill than the transparency checks, which is your next question.
Right. Yeah, but I fully understand. I think some of the also people that listen to this podcast need sometimes a bit of elaboration on understanding all that complexity, because it feels like we have seen for the European Commission the pilot study, and they recommended that patent examiners could be well equipped to do it. They had, good results of claim charting. So is that something you think makes sense? An examiner that actually looks at novelty and inventive step, but now they should also be trained to claim chart. Is that something that makes sense to you, or?
Yeah, so the trouble with that I see, and I think Tim, this could be an interesting topic for your next podcast with a patent prosecution expert. My understanding of those examiners is that they are experts in, examining claims and prosecuting patents, in the sense that they have to check whether these claims are novel and whether they are new inventions that are patentable based on, prior art and based on existing inventions and patents. What they don't have is the knowledge of products in the marketplace and what these claims may read on. They also don't have the knowledge of what could be the validity and infringement likelihood of these claims, right? Those are difficult things and separate skill sets from examiners that would require far more technical and product knowledge that is more up to date and on the ground. So, it's a worthy exercise. I reserve the right to remain skeptical with what I have seen it requires in the industry.
Right. No, well understood. I think my understanding, and correct me if I'm wrong, there are basically two cases where claim charting is needed. First of all, if you want to license your patent portfolio, you want to have a case. So you have to provide some evidence that at least one patent is essential, right? So the other party is using and practicing a patent. That is, and one is enough, right? To have a case, one is enough. But the second sometimes where claim charting is happening is when they try to identify out of your whole portfolio, what is the actual share of truly essential patents and how does it compare to the whole market, right? Your Qualcomm share of all 4G patents compared to any, patent holders' patents. And I think getting the case, right, evidence for one patent that is essential is probably the easy one, but now the second one is difficult. And people call it a top-down approach when they do this. In your opinion, what is actually a good way to determine a fair friend rate and a fair estimation of a share? Is top-down even working for you guys very well, or would you say the comparable license is a much more efficient approach to do that?
So I'm an economist, as are you, Tim. Let me put it this way. If somebody comes to my neighborhood and says, hey, the aggregate price cap of all the houses in your neighborhood is, I don't know, $1 million. And the price of your house is now going to be determined relative to others based on the square footage of your house, and no other attributes may be considered. It's that simple. I'm not sure if I would go for that or the market would go for that. So that's my view of the top-down approach. It's a forced central planner approach that simply doesn't work in markets. And it's too simplistic, and it's taking this real big fallacy in its central thesis, one that there's an aggregate price cap, which none of us economists can really quite agree to, because it's just not how markets work. And second, that you can determine the relative value of patent portfolios based on simple counts. And that, you and I know, with very long established economic literature, has been proven false again and again and again, right? There's a very well established economics of innovation literature that says that patent counts are completely uncorrelated to value. And the analogy that I like to draw here is, it's like, I have coins in my pocket, you have coins in your pocket, and we're counting the number of coins without actually paying any attention to the denomination to try to calculate who has more money. It's just completely a pointless exercise. So, just like back to my real estate analogy, a price of a house is determined by the market conditions. How valuable is an asset in the current market based on its demand, based on multiple attributes. And to me, comparable licenses is the most close approximation to a real market functioning.
But isn't the comparable license also sometimes a chicken and egg problem? What if you don't have a comparable license yet? How do you start with that? Who is going to be the one who evaluates your house, right? I mean, in a way that is also not patent counting, but maybe patent valuation. How that is, of course, something that is done.
Absolutely, and there are methods for doing that, right? There are various kinds of sophisticated methods, like simple hedonic regressions, or understanding the value of different attributes comes into account. I mean, that is the problem that is worthy of a economic modeling and solutions, right? So the sooner we get away from these simplistic approaches that are attractive because they serve an easy solution for a judge or a jury, but just won't ever bear ground in the real markets, the more likely we are to put our resources as a community to identify models for actual valuation, like in real estate markets.
And just to get maybe an understanding of this, how can you give like an example how one patent may be essential, and the other one is essential to cover maybe a very small applicational improvement, let's say, while the other one is a core layer fundamental invention? Can you just, you're the technical expert, give an example of that?
You hit it on the head. That's exactly right. So back to the money analogy, like you may have a dollar coin and I may have 20 pennies in my pocket, but your one coin is worth much more than my 20. And that's the real world of patents, or in inventions or startups or any world of ideas, right? So one simple example is, like, imagine a patent that covers a very important technology for millimeter wave beam forming, right? How do we use this hostile real estate, which is not designed for wireless communications, millimeter waves, high frequency, where waves travel very fast and they dissipate and they can't, be used for communication. But we need to now, because the rest of the spectrum has been squeezed and used, optimized like real estate on the beachfront. So how do we use this very difficult terrain for wireless communications? We form beams like laser beams and we let them travel far enough. That is far more worth to me, like, or to the, technically, and much more resources went into this kind of a solution than, hey, we need to form the right kind of packets that need to transmit from point A to point B to carry the information that is required, right? So this is a very simple example of far more valuable core technologies that just can't be quantified.
And just to explain a bit how a comparable license would better cover those value differences or core technology differences, how does a comparable license work? What is typically, presented to a licensee, and how do they understand what's a comparable license?
So that's a great question. And remember that in this market, there aren't that many licensors, and frankly, not that many licensees either. They're really just a handful. You can count them in your one hand, maybe two. And they know the market, like you would know the market before you buy a house. And they do these claim chart negotiations that are complex. that they invite their experts, technical, legal, they hire experts from outside, and they sit down on the table and they understand what the technology is, what claim charts are talking about. And they also happen to have the overall industry understanding of their hundreds of engineers going to the standards over the years, reputation of knowing who are the people who have the most important, most quality-based patents and portfolios. So all of that, to me, like any other market, goes into account in creating this real value of assets.
And understanding a bit, I mean, again, there's two arguments from the policy debate. I keep hearing the argument: how can we make sure that licensees don't pay for non-essential patents, basically? While of course within a portfolio of essential patents we have these big value differences, but for that pure reason, let's say, for making sure that only essential patents would be licensed, is for that particular reason a claim charting database useful, or still that would be difficult because, as you said, how even essentiality is hard to determine?
Yeah, so I think, Tim, let's call it what it is. You're calling for, you're asking if a solution of what we call transparency is going to help, is more transparency of which patents in a portfolio are essential and which are not essential going to help. So for our audience, let's remind them that when companies or inventors disclose their patents as potentially essential to standards bodies, remember the scope and size of these, they don't, like the standards bodies don't check whether these patents are truly essential or not, because these are thousands of patents over hundreds and thousands of technology solutions. So in that kind of a universe, how do you determine which patents are actually essential and which patents are not, and which should be licensed and which should be not? That is a great question. First is, these technologies are always licensed based on a portfolio and not based on single patents or just a few bundle of patents, right? These are tech portfolios, not biosciences, where a patent covers a drug. So that's point number one. So I think it's less of a problem in our world, but regardless, transparency, let me state this very clearly, is a good thing. It is a non-controversial issue in and of itself, because which patents and whose patents are essential or not, it's good for both licensors and licensees of patented technologies. The issue lies herein, in the complexity of determining this. So the question we need to ask is, what's the end goal, number one, and what's the cost, number two, right? That's the question. It's not like, is it good to know which patents are essential or not? Of course it is, but how do we get there, and how do we use it? The problem is, and you know this, when you prosecute patents, they're prosecuted across different offices. You write a claim, but 5 years later, the patent is granted, and you don't know what claims will be granted, what claims won't be granted. There's a 5-year or more number of years window where this patent application takes time to become a granted patent. So there's uncertainty there in the patent system itself. And then there's uncertainty in the standard, right? Remember, it's not one monolithic thing. Going to the standards meeting again and again, the standard is evolving, it's a living thing. You don't know if your invention is actually going to make it in the standard or not. So you're chasing two moving targets as a matter of definition. So you get the best experts in the room and throw money at the problem. I don't care. You can't get rid of that underlying uncertainty that exists as a system definition, right? So we got to live with that uncertainty. And then the question is then, how much cost are we willing to pay to reduce as much of this uncertainty as possible? And there is a balance here, right? If I say, Tim, I'm going to disclose my patents as early as possible, this means there is going to be more noise because I don't know what will happen to the standard or the patent. If I say to you, I'm going to disclose this as late as possible, there is going to be less noise, but the licensees are now less happy because they're saying, we don't know which patent you may disclose or not. So we have to come up with some kind of a real compromise. And again, I go back to your and my line of work, economics. I feel the answer is not in central planners trying to devise this or that fancy mechanism to say, hey, patent offices, we give you these, trucks of money and go figure out and find a central planner approach to identifying which patents are essential or not. But it is in designing the right mechanism, the right incentives for companies themselves to not over disclose and not under disclose. And we can talk about why that's broken right now. There is, the way the law and the policy has developed, there is more incentive to over disclose than under disclose, because there is a far, far higher cost to under disclosing.
Right. Yeah. I mean, even rulings that find patents non-enforceable because they were late disclosed, right? And again, what is late? Even the ETSI policy is very vague about it. But obviously, I mean, I would, if I were a patent owner, disclose as early as possible if there's the slightest eventuality that these become enforceable, right? That I understand, right? And you're right. That's the thing. Economists think always about incentives, and I think that's the right approach. How can we set incentives right? Maybe one thing to elaborate on this moving target, which I always think is the perfect way to describe it, and some business realities, because sometimes people really think you license single patents. But you're right, it's portfolios, and it's also portfolios, not today, but predicting the future, right? Could you elaborate on that a bit?
Yeah, when the, well, to some extent predicting the future, but yeah, I think.
Or put differently, let's say I'm a Berlin startup and I get access to the Qualcomm SEP portfolio. I would also get access, let's say, licensing 4G to patents that will just be granted and be verified essentially. Okay. While other patents of your portfolio may expire, right? I mean, that is just a business reality. You find somehow a conclusion on, yes, some parts of our portfolio will expire, but we have new ones coming in that it also covers. That kind of contracts, I think people are not aware of sometimes.
Yeah, remember when I said, you can count the licensees and licensors on your hand, because it isn't a very lucrative business to be licensing small startups and SMEs.
Right. I mean, that is that probably
they don't have a large enough volume, right? Yeah. But regardless, I think you hit upon it. I think we describe this as a leaky bucket analogy. So there are some patents that are expiring, that are leaking out of the portfolio. And there are a lot of patents that are going into the bucket as it's flowing, the inventions are flowing in. And as a matter of, practical reality ease, you generally license the bucket, the portfolio on an ongoing basis, knowing that there will be some expirations and there will be some new things coming in.
Right. I mean, I'm just, the reason why I'm asking that, because sometimes the business reality, it's not about having an 100% accurate system that covers any essential patent or kicks out any non-essential ones. Because of that moving targets, it's impossible. Your patent that you license today becomes essential tomorrow because the next release approved that one contribution of yours, and it is essential. You're gonna go back to that lengthy licensing negotiation and say, hey, I have another one, you have to pay more now. Not gonna happen, right? And these kind of business realities people sometimes don't get, right?
Yeah, exactly.
And and that's just what I'm wondering. Okay, but great. One other thing that has been argued a lot is with 5G, really understanding what is essential and not could be even more difficult because of all these application layers. Can you also explain that a bit? Is it really true that some applications may use parts of 5G and others not, and then not all patents essential to some specifications are used? How's that increase complexity there, or is it more like a rumor and most patents are essential and remain essential no matter what the application is?
Okay, so that's an interesting question. So, I'll go back to my analogy of thinking of the standard as a blueprint of a building. So you have the foundations that are laid, and then how much you use or how much you don't use, or like I don't know, for the lack of an analogy, maybe think of highways. How much you use and how much you don't use depends on what kind of vehicle you're driving and how often you're driving it. And pay per use is a very naturally understood thing. Like for us, this is across industry, a natural thing to do. And I think that's what we're going to see with 5G, right? The licensing rates are going to differ, and the methods are going to differ based on what the use cases are. Let's just take two extreme examples, right? A cell phone. Put it on airplane mode and tell me what you can do. So you use the cellular functionality to the hilt. Most of the things you're using the cellular functionality inside the cell phone. Now imagine you're on a wheelchair and you're using it most of the time as a regular wheelchair, and there's a wireless, sensor in it. And it only activates if, in the case of an accident, it trips and it sends a signal. those are two different use cases. So of course you have to come up with use-based licensing. And that is a lot I think we are going to have to see in 5G. And I know that we are planning for it and accounting for this, Tim, as the industry is like auto licensing is looking very different from smartphone licensing, and that's going to continue.
Yeah, I even had one person who recommended to somehow, I don't know, you're the technical expert, to somehow measure the transmission of data packages and defining the license on that. You know, as you said, your phone is constantly exchanging and sending and receiving data, while maybe a small sensor does that only every second day in a very small data package, right? So that, I don't know if that is a solution. I'm not a technical expert of how difficult it is to measure that, but that was a proposal I heard once.
And that is probably why, you know, the licensing the way, like in across industries, I actually did an analysis on this once. Across industry, licensing has evolved in different ways and licensed at different endpoints because of the practical realities of licensing. Like, you know, copyright industry versus our industry, we took the endpoint as a very sort of a natural way to license because you observe the units.
Right.
So it's very straightforward.
Right, it is straightforward, and that's a perfect, you know, perfect way to get to the next question. I think there has been a lot of discussion exactly about this, where to license in the value chain, right? Mm-hmm. Why license on a chip level? Why not license on a smaller sellable unit? But even, you know, the auto industry complains, why not even license on the tier 1 level, which they produce the connectivity box at least, and you know where it ends up. And at least Qualcomm has had somewhere commented that they, in some cases, even license on component level. Can you elaborate on why it is, in your perspective as an economist in particular, much easier or better to license on the end device level?
So, by the way, we do license at different levels too. So
right.
Auto is a perfect example. We do license at tier 1 level at the TCUs and also tier 2, the module makers. They're both licensees. And telematics, right? So we license ultimately, I think that's what the industry does. It licenses wherever it makes sense.
Right.
Now, you know, telematics is easy to license. That's, again, you know, same example as we were talking about the smartphones. Bottom line, you know, it doesn't matter from the perspective of the licensor and from the perspective of a central planner or an economist. It doesn't matter who licenses, as long as, like, my big point is FRAND is equal to FRAND. Like the rate is what the rate is. Doesn't matter at which level you're licensing it in.
Right.
The level of license is only a matter of practically what makes sense. And to me, if that practice is established from the get-go in advance in the industry, the rest of the industry value chain sets an equilibrium around it. And that's what matters. You can't come back like 20 years later and say, okay, now let's change the practice. Because that's when you just, all you do is rent shifting between different players, right? So think about it this way, right? Like in our industry, in the phone industry, you have chips, you have wireless base stations and antennas, you have phones, you have network operators, right? Like if somebody said, let's license based on the number of data packets being sent, the network operators are the best place to license. Now, like other people can tell you why it was impossible back in the day to license network operators, because they were the ones that were pushing the envelope on saying, now let's go to 3G, now let's go to 4G, right? And by the way, you couldn't observe what was happening in those networks. The thing is that if you suddenly say that, and now the licensing as an industry practice, Motorola started with it, by the way, in the 80s, and then everybody slowly started following this. It became a practice to license at the device level because you could observe the device. Now the prices of everything else then reaches an equilibrium around this reality. So you can't suddenly start licensing at a different level because you haven't priced that in at different levels. So that is the problem of like changing the industry equilibrium from outside as an exogenous shock. You gotta do it from the beginning, like in the auto industry.
Yeah, but that is of course now the big question. You know, auto industry was the big next industry vertical. What do we do with smart meters, or you know, what do we do with traffic lights that connect to cars? Is it going to be that device we're looking at, or you know, and even with carrier, as you said, I mean, even there, I think I remember at least some of the network operators argued, you go to the base station manufacturer to get your royalties, right? And that doesn't make sense either, because as you said, how many millions of points of connection one base station manages, right? How many people are making use of that technology matters, right? And not just the base station. I don't know how much they cost, but I guess it's not much.
That's exactly right. And this is the issue that now, like, licensors more than anybody else have to deal with, right? They have to deal with the reality of new use cases, new business practices that need to be established across different industry verticals as 5G becomes a, this global thing. But it's a good problem to have.
Right, you're in the middle of it. And one other thing I feel sometimes with all these complexities and discussions, and you can fight about anything. What actually typically works best is simple solutions, right? And I like, in a way, also that lump sum payment of a patent pool where everyone knows that dollar you pay per, let's say, car. And as you said, you can plan it in, you know the dollar, and then that's just where the price is, and you get everything for it. How important, or how much more important, do you think that is also for IoT and the application of FRAND on IoT devices, where I can see it's impossible to differentiate a smartwatch from a smart meter, or from that smart vacuumer, or other device that is doing something and connects to the network?
So Tim, as you know, basics of price theory say that a flat rate amount works in established markets because there is no risk. Like auto, we announced a $5 per car license, which is, by the way, less than the price of a single car wash, as you know, for like entire use of cellular recipes for your entire lifetime for a connected car. But it's when it becomes a market where there is a certain uncertainty involved, that is why there is percentage-based licensing, right, in the first place, or any percentage-based pricing, because you're sharing the risk of volumes going up and down and not knowing what the reality is going to be. It helps both parties. So I think the simple answer to your question is it will really have to depend on the market and the different players negotiating what is the best point for them.
Yeah, I mean, I'm just thinking also as an economist, is it worth all the money to send all your Qualcomm licensing experts and lawyers and chase Berlin startups and smartwatches? Probably not, right? But you're still using your technology. It's a long tail market, but if it's millions of startups, you may still want something, right? So for that, at least, I could see it's not, it doesn't make sense to look at actual percentages or whatever. There must be a simple system where they can sign up, and it's a box they check, and then the money amount they pay every month, whatever. I mean, I'm just guessing that as an economist. I think that makes more sense.
Yeah, and your guesswork is more or less on the right direction. Now, what actually happens? I don't have a crystal ball just as much as you don't. So these are the considerations that I know that the industry experts are taking into account as they look at volumes, uncertainty, and cost versus benefit analysis to come up with a model that works for the industry. Because remember, you want to come up with a model that works for the industry. If you don't enable and make an industry succeed, then you've lost from the get-go. What are you going to license if there's not going to be a enabled, growing, thriving industry? So there is a very natural feedback in the system that keeps a check and balance that's necessary.
Right. It has to all make sense. But I think it's a lucrative market, and it will remain very exciting to see, because I feel it's just the beginning. Licensing has just started in these new technologies. There's a lot of unlicensed technology out there. I think some people sometimes don't realize how many devices rely on all that technology, and no one is licensing or paying royalties for that, right? I mean, outside of the smartphone industry, at least.
So let me put it this way, when I looked at the data, when we talk about standards and SEPs, most of the discussion is really actually about wireless, cellular, mobile technologies. And here's why. That's where the money is. Majority, like the revenues that wireless generates, or cellular, I should say, is more than all the consumer electronic goods combined. So the discussion is where the success is. That's to be expected.
Well, but when I look at our data, I see also Qualcomm being on the top of patent ownership in things like Wi-Fi 6 or video codec, VVC. Is that also, I think in IoT at least, I can see a lot of use cases there, even maybe not to the extent of 5G, but you see anything, what's your opinion on those technologies, even though you are a cellular standard expert?
No, I think I did go to a few Wi-Fi meetings back in the day, but those are important technologies and important standards. It's simply that, the numbers and the volumes for mobile or cellular cloud, the numbers for anything else, and will continue to for a very long time, right? There are more mobile cellular connections on the planet today than number of people. Now that's hard to beat.
Right. No, I can see that. Maybe one question here, because I have you here as a technical expert, and people keep asking me, and I'm just saying I'm an economist. I actually don't know what 5G really is, because people now get this 5G symbol on their phones. Yeah. Is it the frequency, or is it really 5G yet?
It's early 5G. It's the early releases of 5G, but we aren't seeing the full functionality of 5G unleashed just yet. We are about to. And I would just say this, 5G isn't just a faster 4G or 4G on steroids. It's much more than that. And that's why we are having your podcast and this discussion. It's a technology that is designed to not just connect people to people, you to me, but everything everywhere, connecting. It's the future infrastructure of our fully connected world. And to me, this is why this is such an exciting technology and such an exciting time. And the value it generates is like a big pie of, it used to be $4.8 trillion. It's going to be 13.2 trillion in the next 10 years, according to IHS. And when we talk about licensing, Tim, let us always remember that we are talking about 0.15% of this pie. Let us remember the perspective
of value it creates. Yeah. No, that has been really enlightening, Kirti. Like always, it's great to have your mind as an engineer and economist. That's really, really great. And that was almost your final statement. But I always give you the floor, your elevator pitch. What do you want to keep the people remembering from you from this podcast?
That 5G is a game changer. It's a paradigm shift. And consumers like you and me need innovation to continue for economic growth. And when it comes to these technologies, there is a very classic innovator-implementer divide. There are few innovators, few companies that serve as R&D arm of the industry, a lot of people needed to make sure that those technologies then go to productization. What we need from policy is to stay above the fray and make sure that we continue an innovation engine that serves the needs of consumers. That's what we need, and we need balanced policies to be able to continue.
Great, Kirti. Thank you so much for your final statement. Ladies and gentlemen, that was Kirti Gupta, the Chief Economist of Qualcomm. Thank you for being here on my SEP Couch.
Thank you, Tim.